Thank you for staying with us for KREM 2 News at 6:30. I'm Mark Hanrahan.
And I'm Tom Sherry. Defense lawyers for the accused Freeman High School shooter wants to change his plea from not guilty to not guilty by reason of insanity. Caleb Sharpe was a student there at the time nearly 4 years ago. He admitted to shooting at students and staff in the Freeman High School hallway.
He previously pleaded not guilty. KREM 2's Amanda Rowley examined the court documents today and explained what this motion means now.
Well, the lawyers for the Freeman High School teen shooter filed the motion on Friday in Spokane County Superior Court. It is a request to change his plea from not guilty to not guilty by reason of insanity at the time of the offense. Experts say this plea is difficult to prove and could delay the trial even further.
Nearly 4 years ago, a student at Freeman High School shot and killed one student and injured several others in the school's hallway. He admitted to being responsible for the shooting to investigators, but pleaded not guilty. Last week, Caleb Sharpe's lawyers filed a motion to change that plea to not guilty by reason of insanity.
That's going to be a hard sell.
Jeffrey Feiner is a criminal lawyer in Spokane. He outlines why this type of plea is particularly challenging.
When someone raises insanity, what they're saying is I have a issue that may be a mental defect, or it may be some condition that I was under at the time. I could not perceive the nature and the seriousness of what it was I was doing.
According to the motion, the defense claims they were unaware of the shooter's mental status. That is, until they spoke with Dr. Craig Beaver about the progress of his forensic examination report last month. Dr. Beaver is a clinical neuropsychologist. His opinion is the shooter was legally insane at the time of the offense. The defense recognizes this change of plea is significant for both parties, but they argue it does nothing to change the state's process moving forward. Court records say prosecutors must still get an expert to form their own opinion of the shooter's mental status at the time of the shooting, regardless of Dr. Beaver's opinion specific to insanity. If the state chooses to go forward with its own evaluations, this could delay the trial. Feiner says it is rare a not guilty plea of insanity ends in the defendant's favor. Those who are found guilty could end up in a mental institution.
That person is likely looking at a very lengthy incarceration, and it won't be till they are better. It will be a lengthy incarceration because they're guilty of a crime and they are not being punished because they're not guilty by reason of insanity, but they are removed from society. And sometimes that removal can last decades.
Now, the change of plea hearing is scheduled for Friday, August 20th. His trial has been delayed multiple times. It is currently set for January next year. In the newsroom, Amanda Rowley, KREM 2 News.